Hello, and thank you for joining us today for this presentation on the 2023 Colorado General Assembly legislative session. The purpose of this presentation is to discuss the legislative changes implemented by the Colorado General Assembly during the last legislative session, which affect the division of real estate and/or the practice of real estate generally. The information provided during this presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal question should be directed to a qualified attorney licensed in the state of Colorado. The Colorado General Assembly convened on January 9th of 2023 and adjourned on May 8th of 2023. For additional information on the Colorado General Assembly, please visit https://leg.colorado.gov. The legislative session was an active one, with many bills that had been passed by the legislature. Below you may see a list of the bills which we will discuss in this presentation. First up is House Bill 23-1062, concerning the authority of a metropolitan district to levy a sales tax with voter approval for the purpose of providing parks or recreational facilities or programs. Although not expressly affecting the practice of real estate, HB 23-1062 affects the powers which are granted to the Metropolitan District Boards, and therefore real estate practitioners should be made aware. Many existing homes and most new construction in the state of Colorado is located in metropolitan districts. Metropolitan districts, like homeowners associations, are an important legal construct for buyers, sellers, landlords, and tenants to understand, and the rules and regulations may vary from community to community. Metropolitan districts can also have a significant financial effect on its residents. In the case of HB 23-1062, boards now have the express authority to use revenues for parks or recreational facilities or programs that are located within the district in which the tax is to be levied. Next up, we will discuss House Bill 23-1068, concerning pet animal ownership and housing, and in connection therewith, prohibiting restrictions on dog breeds for obtaining homeowners insurance, providing for the manner in which a pet animals are handled when a writ of restitution is executed, limiting security deposits and rent for pet animals from personal property liens. This bill primarily pertains to landlord and tenant and property management matters. While HB 23-1068 primarily affects pet owners, it also changes several other aspects of Colorado law. Let's take a look at each section of the Act one by one. First, homeowners insurance. Section 10-4-110.8 of the Colorado Revised Statutes now states that insurers may not 1. Refuse to issue, 2. Cancel, 3. Refuse to renew, or 4. Increase a premium or rate of a homeowner's insurance or increase a premium for either homeowner's insurance or fire insurance based on the breed or mixture of breeds of a dog that is kept at the dwelling. However, like many laws, there is an exception. If a dog kept at the dwelling is known to be dangerous, or if the particular dog has been declared to be dangerous, the insurer is not prohibited from the above. The insurer may not ask about the breed or mixture of the breeds of any dog. However, the insurer may ask if the dog is known to be dangerous. Next, writs of restitution. A writ of restitution is a court order to remove tenants and their possessions from a rental premises. Relevant to landlords and property managers, HB 23-1068 directs the officer executing the writ to inspect the premises for any pet animals. At that time, the officer must provide any pet animals found during the inspection to the tenant or contact the local animal control authority if the tenant is not present at the time of the writ of restitution execution. If the tenant was not present during the time of the execution, The landlord must post notice at the premises in a visible place with the name and contact information of the organization where the pet animal has been taken. Furthermore, upon request of the tenant, the landlord shall provide the tenant with the name and contact information of the organization where the pet animal has been taken. Importantly, in this process, no pet shall be removed from the property and left unattended, whether on public or private property. Next, security deposits. A landlord may charge no more than $300 from a prospective tenant or a current tenant to allow a pet animal to reside at the premises. Furthermore, Section 38-12-106 of CRS now states that the security deposit must be refundable to the tenant, whereas previously many landlords required non-refundable security deposits for pets. Next, additional rent. A landlord is not permitted to charge additional rent in an amount that exceeds $35 per month or 1.5% of the monthly rent, whichever is greater, from a tenant as a condition of permitting the tenant's pet animals to reside at the premises. Landlord liens. In Colorado, Section 38-20-102 of CRS creates a lien on tenant's personal property that is then on or in the rental premises. That lien is effective upon household furniture, goods, appliances, other personal property of the tenant, and the members of the tenant's household then being upon the rental premises, but exclusive of pet animals, and then also small kitchen appliances, cooking utensils, beds, bedding, necessary wearing apparel, personal or business records, and documents, and the personal effects of the tenant and the members of the tenant's household. The next bill that we will discuss is House Bill 23-1095, concerning prohibiting the inclusion of certain provisions in written rental agreements. This bill pertains to landlord and tenant and property management issues. Section 38-12-801 of CRS expressly identifies prohibited clauses in leases, including the following. 1. A clause that assigns a penalty to a party stemming from an eviction notice or an eviction action that results for a violation of the rental agreement. 2. A one-way fee-shifting clause that awards attorney's fees and costs only to one party. Any fee-shifting clause contained in a rental agreement must award attorney's fees to the prevailing party in a court dispute concerning the rental agreement, residential premises, or the dwelling unit, following a determination by the court that the party prevailed and that the fee is reasonable. 3. A waiver of the right to a jury trial, except that the parties may agree to waive a jury trial in a hearing in order to determine the possession of a dwelling unit only. 4. A waiver of the ability to pursue, bring, join, litigate, or support any kind of joint, class, or collective claim or action arising from or relating to the term of the tenancy. 5. A waiver of the implied covenant of good faith and fair dealing. 6. A waiver of the implied covenant of quiet enjoyment, except that a written rental agreement may provide that the landlord is not responsible for any violation of the implied covenant of quiet enjoyment that is committed by a third party acting beyond the reasonable control of the landlord. 7. A provision that purports to affix any fee, damages, or penalty for a tenant's failure to provide notice of non-renewal of a rental agreement prior to the end of the rental agreement, except for actual losses incurred by the landlord as a result of the tenant's failure to provide any such notice required pursuant to the rental agreement. 8. If a provision that characterizes any amount or fee set forth in the rental agreement, with the sole exception of set monthly payments for the occupancy of the premises as rent, for which all remedies to collect rent, including eviction, are available. Such amounts and fees include any fees for utilities or services and any other charge that is not construed as rent. 9. A provision that requires a tenant to pay a fee markup for a service or for which the landlord is billed by a third party, except that a written rental agreement may include a provision that requires a tenant to pay either a markup or a fee in an amount that does not exceed 2% of the amount that the landlord was billed, or a markup or fee in the amount that does not exceed a total of $10 per month, but not both. 10. A provision that purports to allow a provider operating under any local, state, or federal voucher or subsidy program to commence or pursue an action for possession based solely on the non-payment of utilities. Finally, the Act also addresses a few exceptions to the above reference rules. First, Section 3812-801 exempts certain provisions from the rental agreement concerning the occupancy of a mobile home. In addition, the same section exempts certain provisions from a duplex or triplex or accessory dwelling unit in ADU, which is defined as an internal, attached, or detached residential dwelling unit that provides complete, independent living facilities for one or more persons, is located in the same lot as a proposed or existing primary residence, and includes provisions for living, sleeping, eating, cooking, and sanitation. House Bill 23-1105, concerning the creation of task forces to examine issues affecting certain homeowners' rights and in connection therewith, creating the HOA Homeowners' Rights Task Force and the Metropolitan District Homeowners' Rights Task Force, and making an appropriation. This bill pertains to the Colorado HOA Information and Resource Center, as well as metropolitan districts. The Colorado General Assembly has made the determination that it should take an earnest look at the state of affairs surrounding common interest communities, also known as CICs, and metropolitan districts in Colorado. While the General Assembly has already adopted the Colorado Common Interest Ownership Act, what we refer to as Kiowa or CCIOA, and also created the HOA Information and Resource Center, which is lodged in the Division of Real Estate, as well as having adopted Title 32 of the Colorado Revised Statutes to address metropolitan districts. This act creates two task forces which will look further into the rights of homeowners living in CICs and metropolitan districts. Specifically, the HOA Homeowners' Rights Task Force will convene and look at issues confronting HOA homeowners' rights, defining authorities and practices of boards, foreclosure practices, communications with HOA homeowners regarding association processes and HOA homeowners' rights and responsibilities, association records, the complaints that have been received and analyzed by the HOA Information and Resource Center, complaints made to any homeowner advocacy groups, and other laws that affect common interest communities. The Metropolitan District Homeowners' Rights Task Force will examine the following issues: levying taxes and the authority therefor, foreclosure practices, communication with homeowners regarding metropolitan district processes and homeowner rights and responsibilities, governance policies including voting and election policies, the process by which metropolitan districts can transition into a common interest community under Kiowa, and the recommendations and reports of the HOA Homeowners' Rights Task Force. There are several deadlines, and each task force will issue reports on their findings. The next bill that we will discuss is House Bill 23-1120, concerning evictions protections for residential tenants who receive public assistance, and in connection herewith making an appropriation. This bill relates to landlord and tenant issues as well as property management issues. The Colorado General Assembly considers the disparity between landlords' and tenants' access to legal representation to be a significant one. Notably, the General Assembly referenced a study that found that renters are represented by counsel in only 1% of eviction cases, while landlords are represented by counsel in 77% of cases. This information, in conjunction with the fact that Colorado is experiencing a housing shortage, estimates of which are the shortage is approximately 325,000 units in 2022 alone. Accordingly, HB 231120 seeks to address these and other related issues. Complaints in forcible evictions and detainers, FEDs, now must include an affidavit about whether the tenant receives supplemental security income, Social Security disability insurance, or cash assistance through the Colorado Works program, and the complainant and residential tenant participated in mandatory mediation and the mediation was unsuccessful, or two, in the alternative, whether the complainant and the residential tenant did not participate in that mandatory mediation. The Act requires that mediation must be conducted by a trained, neutral third party and be provided at no cost to the residential tenant and should take place within 14 days of the request made by the landlord. HB 231120 requires that a written rental agreement include a statement that prohibits the source of income discrimination and requires a non-exempt landlord to accept any lawful or verifiable source of money paid directly, indirectly, or on behalf of a person, including income derived from any lawful profession or occupation, and income or rental payments derived from any government or private assistance, grant, or loan program. However, it is important to address that this provision does not apply to a landlord with 5 or fewer single-family homes. Prohibited clauses that the landlord may not include now are: 1. A waiver of mandatory mediation required pursuant to Section 1340.110 subsection 1 of Colorado Revised Statutes, or 2, a clause which allows the landlord to recoup any costs associated with mandatory mediation which is required by Section 13-40-110 of the Colorado Revised Statutes. The next bill that we will discuss is House Bill 231125, concerning the modernization of the process to change groundwater well owner contact information. This bill pertains to the purchase and sale of real estate by real estate brokers. HB 231125 requires that any owner of an unexpired well permit that changes a name or contact information from that is on file with the state engineer must do so within 63 days, and that the buyer of residential real estate that results in the transfer of ownership of a well must update the state engineer within 63 days. In addition, if a transaction included closing services, the person providing those closing services shall have 60 days to submit the change in owner name form. House Bill 231134, concerning mandatory provisions in home warranty service contracts, and in connection therewith, requiring a home warranty service contract to include terms allowing a homeowner to replace any kind of certain gas-fueled devices with a device that operates on electricity. Home warranty service contracts cover repairs and replacements for expensive home appliances and systems. The Colorado General Assembly has determined that a home warranty that covers like-for-like replacements in the event of a claim may cause a disincentive for people to purchase cleaner or more energy-efficient appliances. Accordingly, HB 231134 was passed. For those home warranty service contracts that are executed after July 1st of 2024, a homeowner is allowed the option to replace a gas-fueled appliance with a similar device of the homeowner's choosing that operates on electricity rather than gas. The contract may require the homeowner to pay any costs in excess of the cost of replacing the gas-fueled appliance with the gas-fueled appliance. Specifically, 1. If the homeowner is replacing a gas-fueled furnace, HVAC system, a boiler, or a water heater, the contract must allow the homeowner to replace the appliance with a heat pump-based system as well. 2. If the homeowner is replacing a gas-fueled stove, the contract must allow the homeowner to replace the appliance with an electric stove or an induction stove. Again, this bill applies to home warranty service contracts that are executed or renewed on or after July 1st, 2024. Up next is House Bill 23-1174, concerning homeowners insurance and in connection therewith requiring certain reports related to the cost of reconstructing a home, increasing the notice requirement before an insurer can cancel or refuse to renew a homeowner insurance policy, creating a guaranteed replacement cost coverage in homeowners insurance, and making an appropriation. Concerned about the cost of reconstructing homes in Colorado, the Act requires an annual report, which is due on April 1st of 2025 and annually thereafter, on the cost of reconstructing homes in Colorado. The report will consider various factors, including differing regions of the state, home types by design structure, different home customization types, and other factors which are set forth in Section 10-4-110.8 of the Colorado Revised Statutes. Next, the Act requires that an insurer must mail by first-class mail to the named insured at the last address shown in the insurer's records at least 60 days in advance a notice of intent to cancel or refuse to renew a policy. The notice must specifically state the reason or reasons for proposing to take such action. Exception to this rule is where cancellation is for non-payment of the premium, in which case the insurer needs to provide at least 10 days notice of cancellation accompanied by the reasons for taking such action. Next, we will discuss House Bill 23-1186, concerning remote participation in a residential eviction filing in county court, and in connection therewith, making an appropriation. This bill pertains to brokers and landlord and tenant issues. According to House Bill 1186, the General Assembly is aware of the challenges and the high cost of litigation in Colorado courts. Attending court proceedings in person can require renters who face eviction to miss work, find and fund childcare, and incur transportation costs. Therefore, to create an equitable process, the Colorado General Assembly amended Section 13-4-113-5 of the Colorado Revised Statutes to require that courts allow either party and any witness to choose to appear in person or remotely by telephone or video on a platform designated by the court at any return, conference, hearing, trial, or other court proceeding. It is important to address that if once a party or witness has chosen a method by which to appear, that party or witness can elect to change the manner by which to appear. However, if the party or witness contacts the court within 48 hours before the scheduled appearance, the court has discretion whether to approve the parties or the witnesses' requested change in participation. Needless to say, with electronic appearances, there is the possibility of technological failures. In such an event, the court is directed to attempt to reestablish a connection, but if that is unsuccessful, the court shall reschedule the hearing no later than 1 week after the originally scheduled hearing. House Bill 23-1233, concerning energy efficiency and in connection therewith, requiring the State Electrical Board to adopt rules facilitating electric charging. This bill pertains to real estate brokers, landlord-tenant issues, as well as common interest communities. The General Assembly has regularly found that reduction of greenhouse gas emissions and vehicle electrification are key strategies for the transportation sector. HB 23-1233 acknowledges that it is less expensive to build electric vehicle-capable parking spaces at the time of initial construction rather than retrofitting after initial construction. The State Electrical Board will prepare rules surrounding EV power infrastructure for multifamily buildings, applying both to new construction and major renovations of multifamily buildings. These rules are required to be prepared by September 1st of 2023 and shall take effect sometime after March 1st of 2024. In the case of tenants, tenants may install at their own expense a Level 1 or a Level 2 electric vehicle charging system. These provisions pertain to tenants in both residential rental properties and commercial rental properties. In the case of common interest communities, which include HOAs, POAs, condominiums, and cooperatives, the bill clarifies that a board shall not prohibit a unit owner from the installation of a Level 1 or a Level 2 electric vehicle charging system in or on their own unit, in assigned unit, or deeded parking space that is part of or is assigned to a unit, or 3, a parking space that is accessible to both the unit owner and other unit owners. A board shall also not restrict parking based on a vehicle being a plug-in hybrid or a plug-in electrical vehicle. House Bill 23-1254 applies to both real estate brokers as well as landlord and tenant issues. It is entitled Concerning the Conditions Covered Under Warranty of Habitability for Residential Premises and in connection therewith specifying a landlord's requirements to remediate a residential premises that is damaged due to an environmental public health event, expanding what constitutes retaliation by a landlord, and describing situations in which a tenant may terminate a lease after the premises has been damaged due to an environmental public health event. Many of you may be aware of the Marshall Fire. It caused significant damage, burned over 6,000 acres, damaged nearly 1,100 homes, and resulted in more than $500 million in damages. This bill addresses the resulting health concerns and habitability issues with the intention to return residential premises to a condition that protects the health and safety of residents from environmental contaminants. Pursuant to the Act, the warranty of habitability between the landlord and tenant is breached by the landlord if the residential premises is uninhabitable or unfit for human habitation, or not in compliance with the standards described in Section 38-12-505 of the Colorado Revised Statutes for the remediation and cleanup of residential premises that has been damaged due to an environmental public health event. In such an event, a tenant should give the landlord written or electronic notice of the condition and shall retain sufficient proof of delivery of the notice. Upon receipt, the landlord shall respond not more than 24 hours after receiving notice, except that the landlord may take up to 72 hours to respond to the tenant in the case that the residential premises is inaccessible because of the damage due to the environmental public health event. Remediation shall be completed within a reasonable amount of time and shall be completed at the landlord's expense. Furthermore, upon remediation, landlords shall provide documentation that demonstrates compliance with the standards that are described in the Colorado Revised Statutes. Landlords should understand clearly that evidence of a submission of an insurance claim does not constitute evidence of remediation. A tenant has the right to terminate the lease if the residential premises is uninhabitable and 1. The landlord has not been able to remediate the conditions of the residential premises so that it is safe for habitability within 60 business days after the landlord has received notice. 2. The tenant gave the landlord written or electronic notice that the premises is not safe for habitability due to damage from an environmental public health event. And 3. The landlord is not able to provide adequate alternative housing accommodations for the tenant for the duration of the time that the residential premises is being remediated. If the tenant is a member of a vulnerable population, the standards for termination of the lease differ. First of all, a vulnerable population is defined as children, individuals with asthma, individuals with disabilities, individuals who are pregnant, or any other group of individuals that has health concerns that could make the individual more susceptible to environmental contaminants. In the case of vulnerable populations, a tenant may terminate the lease if the tenant has given written notice or electronic notice, the landlord has not been able to remediate the conditions of the premises, the landlord is not able to provide adequate alternative housing for the tenant for the duration of the time that the residential premises is being remediated, and the tenant has provided the landlord with evidence from a licensed medical doctor that the tenant's condition is such that continued living in the residential premises would be detrimental to the tenant's health, safety, or quality of life. Next is House Bill 23-1266, concerning the suspension of reverse mortgage from the repayment of requirement when a force majeure renders the subject property uninhabitable as a principal residence. This bill pertains primarily to mortgage loan originators. Many real estate practitioners are already aware that reverse mortgages are a useful tool that has evolved to offer solutions to many Coloradans at various stages of life. One condition in most reverse mortgages is that the lender must reside in the property, though. Therefore, what happens when the owner is temporarily absent from the home as a result of a natural disaster or other force majeure, which renders the home temporarily uninhabitable? In such a case, HB 23-1266 allows an owner to be temporarily absent when the home is uninhabitable, provided that 1. The borrower is engaged in repairing the home with the intent to reoccupy the home as a principal residence or to sell the home. 2. The borrower stays in communication with and reasonably responds to inquiries from the lender while the home is being repaired. 3. The borrower complies with all other terms and conditions of the reverse mortgage. And 4. Repairing or rebuilding the home does not reduce the lender's security. Consumers and practitioners alike should be aware that the provisions of HB 23-1266 apply to reverse mortgages for home mortgages that have been rendered uninhabitable by a natural disaster or other force majeure that occurs on or after the effective date of this act. The effective date of this act is June 7th, 2023. House Bill 23-1287, concerning a county's regulatory authority related to short-term rentals of lodging units. In the state of Colorado, the Board of County Commissioners may adopt ordinances for controlling or licensing of the matters that are of purely a local concern. This includes short-term rentals. For vacation rental services, a Board of County Commissioners may require a vacation rental service that displays a short-term rental for a lodging unit to obtain a local short-term rental lease license or a permit number, and require the removal of a listing if the short-term rental license or permit is suspended or revoked or has been issued a notice of violation. Now we are on to the Senate bills. Senate Bill 23016, concerning measures to promote reductions in greenhouse gas emissions in Colorado and in connection therewith making an appropriation. This bill pertains to landlord-tenant issues as well as the HOA Information and Resource Center. Generally, SB 2316 addresses the various climate goals of the state of Colorado. By and through the Colorado Energy Office, the state of Colorado is tasked with working with communities, utilities, and public and private organizations to attain several goals. For purposes of the Division of Real Estate and the HOA Information and Resource Center, the following sections have been amended. Section 38-30-168 sub 1b, the definition of renewable energy generation device is expanded to now include, quote, a heat pump system as defined in section 39-26-732 subsection 2C of the Colorado Revised Statutes, unquote. In addition, the Colorado Common Interest Ownership Act, Kiowa, is amended to clarify the definition of an energy efficiency measure, which includes now, quote, a heat pump system as defined in section 39-26-732 sub 2C of the Colorado Revised Statutes, unquote. All references to energy-efficient matter can be found in Kiowa at section 38-33.3-106.7. Senate Bill 23077, concerning prohibiting the inclusion of certain terms in a broker contract. This bill applies to all licensees that are regulated by the Colorado Division of Real Estate. A broker engagement contract is defined as, quote, a written contract in which a seller, buyer, landlord, or tenant of a residential premises becomes the client of a broker and agrees to retain the services of a broker in the future and promises to pay a broker a valuable consideration, or agrees that the broker may receive a valuable consideration from another person in exchange for the broker to either produce a seller, buyer, tenant, or landlord ready, able, and willing to sell, buy, or rent the residential premises, or to perform other services, unquote. SB 2377 states that a broker engagement contract must not, 1, purport to be a covenant running with the land or be binding on future owners of interests in the real property, 2, must not allow for assignment of the right to provide services without notice and agreement of the owner of the residential premises, and 3, must not purport to create a recordable lien, encumbrance, or other real property security interest. Any such lien, encumbrance, or other real property security interest is void and unenforceable. With that understanding, though, the bill also states several exceptions which do not apply. Those are 1, a home warranty service contract, 2, a building warranty or similar product that covers the cost of maintenance of a major housing or building system, such as the plumbing or an electrical system, for a specific period of time after the date on which the house or building is sold. 3, an insurance contract. 4, an option to purchase, a put requirement to purchase, a right to first offer, or a right of first refusal. For those of you that are unfamiliar, a put option grants the right to the owner to sell some amount of the underlying security at a specified price on or before the option expires. 5, a declaration created in the formation of a common interest community or an amendment to the declaration. 6, a maintenance or repair agreement entered into by a unit owners association. 7, a loan or a commitment to make or receive a loan, which loan or commitment is secured by real estate. 8, a security agreement under the Uniform Commercial Code relating to the sale or rental of personal property or fixtures. 9, water, sewer, electrical, telephone, cable, or other regulated utility service providers. 10, a property management agreement by which the owner of the real property contracts with a party to provide management services for the maintenance, ownership, operation, or lease of a residential premises. Pursuant to the bill, should a person now offer a consumer broker engagement contract which violates subsection 2 of section 12-10-403.5 of CRS, has committed an unfair or deceptive trade practice, which is defined in section 6-1-105 subsection UUU of the Colorado Revised Statutes. Senate Bill 23110, concerning transparency for metropolitan districts. This bill pertains to real estate brokers as well as generally to metropolitan districts. SB 23110 imposes requirements for the service plans, annual meetings, and other disclosures in a real estate transaction. The service plan is a document entered into between the developer and either 1, the Board of County Commissioners, or 2, the municipality that creates a metropolitan district. In any event, SB 23110 requires that service plans need to contain, quote, the maximum mill levy that may be imposed for the payment of general obligations and indebtedness, unquote, and the, quote, maximum debt that may be issued by the district, unquote. Next, for any metropolitan district organized after January 1st of 2000 and that has a residential units within its boundaries now must, quote, conduct an annual meeting in addition to any other board meetings held pursuant to this section, unquote. The meeting must be held either in person or virtually or both. However, should the meeting only be held in person, it must be held at a physical location within 5 miles of the metropolitan district's boundaries. At this annual meeting, the board is prohibited from taking any official action, but it must include the following. 1, the status of any public infrastructure projects. 2, the status of any outstanding bonds. 3, a review of the unaudited financial statements for that calendar year. 4, an opportunity for the public to ask questions about the metropolitan district. And 5, a public comment period at which the board will adopt the annual budget. Notice of the annual meeting must be provided in accordance with Section 32-1-903 subsection 2 of the Colorado Revised Statutes and be posted on the Metropolitan District's website. SB 23110 also amends Metropolitan District Boards' financial powers. Boards must provide certain disclosures prior to the issuance of debt to any director of the Metropolitan District and must receive a statement from a registered municipal advisor that the interest rate does not exceed 1, the interest rate allowed under subsection 7B of this section, or 2, the current market rate interest rate based on criteria determined by the registered municipal advisor. Important for all real estate licensees is that all property sales on or after January 1st of 2024, which are located in the boundaries of a metropolitan district, which is organized on or after January 1st of the year 2000, the seller shall provide the official website established by the Metropolitan District on the Colorado Real Estate Commission approved seller's property disclosure form or any other concurrent writing. Next is Senate Bill 23148, concerning property used to illegally manufacture drugs and in connection therewith making an appropriation. This bill pertains to appraisers, brokers, mortgage loan originators, as well as landlord-tenant issues. SB 23148 creates a public database for use after January 1st of 2024 of residential real estate that has been used as an illegal drug laboratory involving methamphetamine. Properties shall remain in the database for 5 years after the certificates of compliance, which are issued by a contractor that the property was demolished or has met certain cleanup standards. Law enforcement has certain required disclosures as set forth in SB 23148 as well. In addition, if a seller becomes aware that the property was an illegal methamphetamine drug laboratory, but remediates the property and receives the necessary certificates of compliance, then the seller is not required to disclose that the property was used as a methamphetamine drug laboratory to the buyer. After 5 years, the property is no longer included in the database. This bill applies to a manufactured home, mobile home, condominium, townhome, home sold by the owner, a financial institution, or by the Federal Department of Housing and Urban Development, a rental property, including an apartment, and short-term residences such as motels or hotels. Senate Bill 23178, concerning removing barriers to water-wise landscaping in common interest communities. This bill pertains to real estate brokers as well as the HOA Information and Resource Center. Water-wise use of Colorado's resources is a priority for the Colorado General Assembly. This bill allows owners greater flexibility in deciding whether to install xeriscaping, non-vegetative turf grass, or drought-tolerant vegetative landscapes on property which the owner is responsible for maintaining. This bill only applies to a unit that is a single-family detached home. To be clear, it does not apply to a unit that is a single-family attached home that shares one or more walls with another unit, or any condominium. Each association in Colorado shall select at least 3 pre-planned water-wise garden designs that are pre-approved for installation in front yards within the common interest community. https://plantselect.org is one available resource where pre-planned designs can be identified. If an association has a public website, it shall post information concerning the pre-approved garden designs on their website. Furthermore, an association must 1. Not prohibit the use of non-vegetative turf grass in the backyard of a residential property. 2. Not unreasonably require the use of hardscape on more than 20% of the landscaping area of a unit owner's property. 3. Allow a unit owner an option to consists of at least 80% drought-tolerant plantings. And 4. Not prohibit vegetable gardens in the front, back, or side yard of the unit owner's property. Vegetable garden means a plot of ground or an elevated soil bed in which pollinator plants, flowers, or vegetables or herbs, leafy, greens, fruits, or other edible plants are cultivated, unquote. Finally, if an association knowingly violates this act, a unit owner who is affected may bring a civil action to recover up to a maximum of $500 or the unit owner's actual damages for violation, whichever is greater. Our final bill that we will address in this presentation is Senate Bill 23206, concerning information about radon in residential real property transactions. This bill applies to all real estate licensees as well as landlord-tenant matters. Radon is an odorless, colorless, tasteless, and radioactive gas that is naturally occurring in soil and groundwater throughout Colorado. All licensees and buyers and sellers and landlords and tenants should understand that a buyer of residential real property has the right to be informed of whether the property has been tested for elevated levels of radon, and therefore a disclosure is required, including the results of any previous test. Landlords and property managers need to be aware that a similar disclosure is required for tenants as well. Landlords and tenants should further understand that failure to disclose is deemed to be a breach of the warranty of habitability as is set forth in Section 38-12-503 of the Colorado Revised Statutes. Thank you for joining the Colorado Division of Real Estate today for its presentation on the 2023 legislative update. The summaries provided herein are not intended to constitute legal advice and are provided by the Division of Real Estate solely for information and educational purposes. If you have additional questions, you might want to review the Division's written summaries provided on its website. Thank you again for joining us today.